All right, Mr. Greer, we will be with you shortly, okay?
Yes, ma'am.
And Mr. Gallagher, who are you coming in on?
Good morning, Your Honor. I'm here for the Tracy Eckert case. I can give you the case number if you need it.
No? Okay, I don't have, oh, I have Elizabeth Cochran. Do I have Dakota Morgan joining me from the jail?
You do.
All right, this is in the matter of Shelby Ann Irving versus Dakota Lee Morgan. So, Mr. Morgan, we are here on a friend of the court show cause and bench warrant for failure to appear. States here that you're ordered to pay $351 a month in child support. And as of today's date, you have an arrearage in excess of $6,719. Do you understand that?
I do now. I just found out about the bench warrant Friday, and I had no idea. I had no idea I was behind that much because up until 2 months ago, I got laid off, and they was taking money right out of my check.
Might be, but you probably have an arrearage from before that, maybe.
It must be from when the time I was homeless.
Right. Well, I mean, it is what it is. Becky, can I get Jeff Anderson, please, from front of the court? All right. So, Mr. Morgan, if you reach the level of $10,000, you can't be, well, at any time, but mostly they look at the $10,000 number. You can be charged with a felony and be facing up to 4 years. And oh, Jeff, you're already here. I'm sorry.
No,
you could be facing up to 4 years in prison. Do you understand that?
I do now.
Okay. So we have not received a payment since October of 2022. When's the last time you made a payment?
That would have been from my gas station job, so that sounds about accurate.
Okay. And then, so are you currently employed?
I got laid off. I went to a job interview this last Friday, and I was supposed to go finish my paperwork and take a drug test today.
Okay. So you've been laid off since October?
I've only been laid off for about a month and a half. The last job I was working at Days Inn right here in Adrian, and I was through a temp agency through Manpower. And I went to them right before I got laid off because I noticed that they want to take.
Sir, hold on a second. So let's back up a little bit. So, Mr. Morgan, you understand you're supposed to pay $351 a month. You have an arrearage in the amount of $6,719.54. This is a first show cause. So do you understand if you plead guilty or found guilty, you could be facing up to 45 days in jail? Do you understand that?
Yes.
Now, you do have a right to have an attorney represent you here today and in all subsequent hearings. If you can't afford to hire one, we can appoint you one at public expense. Would you like an attorney appointed to represent you?
I don't know. I don't know. Do I need one? I'm not sure. I'm not sure what's going on. I don't know if I need one or not.
Well, that's if you have an attorney appointed to represent you, they can explain to you what's going on.
Okay, then yeah, I guess I would want one.
All right. Miss Adams, is Miss Underwood available this morning?
I will check, Judge.
All right. So, sir, you just hang out for a moment. We'll try and get your court-appointed attorney.
Okay.
All right, I do have Mr. Stimson, Mr. Noe, Mr. Gallagher, and Elizabeth Cochran. So, All right, Mr. Noe. Mr. Noe, are you with us? There you go. All right, this is in the matter of Zachary Frederick Greer versus Jordan Elizabeth Plentz, file number 2021-48550 DC. I have David Stimpson appearing on behalf of the plaintiff and Charles Noe appearing on behalf of the defendant. This is the date and time scheduled for plaintiff's motion to show cause. There also was an ex parte that was filed and that was denied, and I set that for hearing on May 15. So, Mr. Stimpson, on your motion to show cause, you may proceed.
Yes, Your Honor. The history, the brief history of this case, Your Honor, is that the parties had a romantic engagement several years ago, resulting in a specific birth of one child. Mr. Greer came to live with Ms. Plentz here in the state of Michigan. He's originally from Indiana. They attempted to raise the child together. That was unsuccessful. They separated as a result of domestic violence on behalf of Ms. Plentz against Mr. Greer. A joint physical custody and 50-50 parenting time order was entered, and it was quite contentious rather, throughout the course of that aspect that was ultimately the result of the thing. Some year or so later, Mr. Greer had to change jobs as a result of a declining job market in automotive sales, moved up to the general area of northern Detroit. And as a result of that, he said, you know, I can't really be there every single day for my kids, so let's do some modifications. He agreed to modify parenting time, and Ms. Plentz essentially just refused to provide that parenting time going forward. Some show causes and motions were filed, bringing forth a order in November of last year that she demanded having some form of reintroduction because she had refused to provide the child for the better part of about a year. Mr. Greer indicating he was good with having an introduction, began that introduction. She would not allow anybody but a trained parenting staff to do it. We have a trained parenting staff to do it.
Can you slow down, Mr. Stimpson? One, you guys, I've already read all this, so I don't need you to regurgitate it. I understand attorneys, we like to talk, but so I've read everything. If you could just briefly address anything else, and then Mr. Noe briefly address anything else, but you don't need to recite your motion.
Well, yes, Your Honor, I only highlight it because it's not part of the pleadings, but it's entirely important. He has complied with the terms of that aspect. He's had his sister do some visitation. He's had the agency do some visitation. The agency has signed off indicating that there's no problem. Ms. Plentz is refused still since November, except for these 4 times to provide the minor child. She has now moved out of state and is refusing to provide the child. We're asking that she be held in contempt and that she be required to reinstate every other weekend with Mr. Greer. She is attempting to alienate this kid from him in every way possible.
All right, Mr. Noe, your response.
Thank you, Your Honor. Again, briefly, if you have already read through everything, I'll just directly address some of the issues Mr. Stimpson brought up. Mr. Stimpson, first and foremost, claims that the agency has, I believe, signed off was the term he used. If he has proof of that or documentation of that, I'd really like to see that because I haven't seen that yet. All we have documentation of, and interestingly, Mr. Stimpson attached to his pleadings, indicating that he has in fact not followed the order, has in fact not done his parenting time as he was ordered to do so in our agreement that was struck between ourselves and Mr. Godfroy. He's not followed through the terms. The reasons for the parenting time that was put in place, supervised was necessary, that the extensive supervised was necessary before he was to begin unsupervised. What he's trying to do is skip the unsupervised time, basically not have to pay for it. I think what's really the crux of the issue here, and to proceed directly to unsupervised parenting time every other weekend, as Mr. Stimpson indicated. He certainly can work his way there, but he's not there yet. So I believe that in terms of the show cause, there's nothing to show cause my client for, because in fact, it's Mr. Greer who's not followed the order. So really, it should be the other way around. So, Judge, if you've already read everything, there's a history here, which I clearly, Judge, you don't need to hear about. But in terms of what we're asking the court to not show show cause my client, as she has followed the order. She's really nothing she hasn't followed the order. In addition to that, Judge, we are asking for attorney's fees. We are asking that you deny his Mr. Greer's request for parenting time modification. Thank you.
Okay, so both parties are right to some respect, but in this case, I can't control the fact that the center will only do 2-hour blocks. He's had 4 let's see. He's completed sessions, although he's a little short on hours, but that would take months if they're only doing 2-hour sessions. So I think at this point, what I'm going to do is kind of go to the next phase. And I'm going to, Mr. Simpson, does your client work on Saturday nights?
Mr. Greer, do you work Saturday night?
No, Your Honor.
All right, so what I'm gonna do at this point is order for 4 weeks. He exercised Saturday at 4 to Sunday at 4. Once he's completed those 4, then he will move to his every other weekend.
Thank you, Your Honor.
Did you
Sorry.
say
This weekend, Your Honor?
I need you to repeat that.
You just spoke at the same time, so I have no idea what anybody said.
Saturday at 4 to
Starts this
Sunday at
weekend.
4.
Yep, this weekend. Mr. Noe?
I was just asking the court, and Mr. Simpson just kind of addressed it. So he'll show up 4 weeks on Friday. So at 4, you said?
Saturday at 4 to Sunday at 4 for 4 weeks in a row, and then every other weekend.
Thank you, Your Honor.
All right, so listen, your file is pretty thick for just a DS or DC case. You guys need to figure this out. Neither of you are horrible people, but you need to start respecting each other, or you're just gonna spend a fortune in attorney fees. So, Mr. Greer, have everything you need for your son at your house. Ma'am, I want you guys to be polite to each other, and this just needs to stop. So, very good. Thank you both. Have a good day.
Your Honor, I assume that also cancels the motion set for May.
Yes, if you want it to.
I do. Thank you.
We will take that motion on. Okay, thank you.
Thank you, Your Honor.
Thank you. All right, Ms. Adams will take that motion off. Okay. Eckert versus Worley. Okay, we're just still waiting for your court-appointed attorney, so just hang out for a moment. All right, in the matter of Tracy Lee Eckert versus Cameron James Worley, Rhonda Sue Howard, and Jack Henry Stewie, file number 21-6813. And I have Elizabeth Ann B. Cochran, P79067, appearing on behalf of the plaintiffs. And I have Brian R. Gallagher, P80013, appearing on behalf of defendants Worley and Howard. I do not have James Hicks, but anyway, so this is a date and time scheduled for defendant's motion to compel. So, Mr. Gallagher.
Thank you, Your Honor. I think we've also got plaintiffs' motions for protective order and motions to quash the deposition subpoena.
We do.
They're basically all dealing with the same center issues here. This is an auto negligence case. We, via request to produce, requested some records from plaintiff, including credit card and bank records. Usually I wouldn't request these kinds of records in a case like this, but whether or not plaintiff was in the state for more than 30 days during 2020 is at issue here. If he was in the state for more than 30 days, he had no fault insurance, but he had Ohio insurance because he lives in Ohio. Regarding the deposition of Miss Engel, we had previously filed a motion to compel these records. We were told, hey, yeah, we'll get you the records, no problem. Although we previously requested them in like August. But after that point in time, when they told us they'd give us the records, they basically said, well, there's an issue here. Miss Engel and Mr. Eckert, our boyfriend and girlfriend, they had they're basically on the same credit cards. Our response was, well, then we need to get our deposition to get this issue sorted out. That's that issue. I think we're entitled to a deposition to figure out what the story is with these bank records and see if they show that he was in the state. They've also requested a protective order. Initially, I really don't have any problem with a protective order limiting the dissemination of the credit card and bank records to third parties, or only filing them in the court under seal to keep them out of public record. But the protective order that they want basically says that, well, we're not going to give you any records that don't show he was in Michigan. But in response to our motion to compel, they basically say, well, the bank records don't show he was in Michigan, because he could have, driven rode a train or been on a bus or flew a plane up to Michigan, when we don't really think that's the case at all. I mean, if anything, the bank records and credit card records would show if you bought a plane ticket or a bus ticket or whatever. Frankly, I think they're kind of trying some circular logic here, Judge, just to try to say that, well, the bank records don't show that he drove in Michigan, therefore you can't have them at all. That's my concern.
Okay, very good. Ms. Cochran?
Yes, Your Honor. The statute that defendant is stating, you keep saying if plaintiff was in Michigan. That's not the standard. The standard is if that vehicle was in Michigan. Asking for a year of somebody's financial records to show that they were in Michigan, not their vehicle, is overstretching, is a fishing expedition. As they said, they're speculating. Oh, well, maybe there'll be this in there, or maybe there'll be that in there. This is absolutely ridiculous. He should not have to turn that over, as it does not demonstrate what they are looking for. Furthermore, when it comes to Mary Engel, they're asking for this after the close of discovery. I've laid out in my brief my positions on this. I think that it's a fishing expedition and should not be allowed.
All right, Mr. Gallagher.
Your Honor, we were provided the information regarding Miss Engel's, being on the same card after the close of discovery. I really didn't need her discovery deposition until they told us, well, she's on the same bank account with the plaintiff. And frankly, like I said earlier, if he was being in Michigan any other way other than driving his car, his records would show that. If he bought a plane ticket or a bus ticket, his records would reflect that. We'd be able to figure out, okay, he's in Michigan because he bought a plane ticket or a bus ticket. He testified that he was in Michigan for a significant amount of time. He said about every week up to November. He was visiting his girlfriend on the weekends, apparently. He was visiting his girlfriend for Thanksgiving on the date of our accident. He was also in Michigan working. So I think that there's enough reason for us to get these records, whereas we wouldn't normally get them, because he's testified. Then basically his testimony's made this an issue. We'd ask the court grant our motion and force and compel the production of these records.
All right, in this case, the parties previously stipulated to compel additional discovery responses from plaintiff. There's been some refusal to provide. Defendants again seek an order to compel answers to interrogatories and requests for production of documents. There's also a request for a motion for protective order. So, I am not going to grant a request to quash a subpoena for Mary Engel. So she will be required to appear for a deposition. I do find that the delay in deposing Ms. Engel is appropriate based on the fact that documents and discovery disclosures were not provided. And I will grant the request to compel filed by the defendant but I will also grant plaintiff's request for protective order. And those documents are not to be disseminated to third parties outside of what is necessary for trial purposes. In light of the fact that any trial in this case would be, we don't even have a trial date, do we?
Oh, Your Honor. Got a pretrial in July.
I don't see any delay as being prejudicial. So, Mr. Gallagher, I guess you can prepare the order.
Yes, Your Honor.
Thank you, Your Honor.
Thank you, Ms. Cochran. Thank you, Mr. Gallagher.
Take care, everyone.
Thank you. All right, so we are just waiting for Ms. Underwood. Ms. Adams, I'm gonna make you co-host. So we're just waiting for Rhonda. So I'll be back in just a minute. Well, we got a couple minutes. I won't come in until Rhonda pops in, sorry.
Oh, go ahead. Green later and I might be getting. Not sure on that one, sorry. Well, I have to rubber seconds, but then going on here. All right.
Waiting for an attorney.
Oh, no, okay.
Oh, yeah, I'll think about it.
But here,
I got it. Sue?
Popped in real quick.
Hold on 1 second, Ms. Underwood. All right, so Mr. Morgan, you had asked for court-appointed counsel. Ms. Underwood, I appreciate you popping in this morning. Did you receive the paperwork on Mr. Morgan?
I have.
All right, so I'm going to put Mr. Morgan into a breakout room with you. He has many questions. And Mr. Morgan, I don't know if you will automatically go to the breakout room or if you will have to use the mouse to click join. But yep, looks like you need to use the mouse, click join, and then go ahead and join that breakout room. All right, Ms. Underwood, let me close that breakout room and bring him back. All right, Ms. Underwood, have you had an opportunity to speak with Mr. Morgan?
I have, Your Honor.
And is Mr. Morgan eligible for court-appointed counsel?
I believe he is, Your Honor, at this
Ms.
point.
Underwood? Okay, how would you like to proceed on behalf of Mr. Morgan?
Your Honor, Mr. Morgan informs me that he is supposed to fill out paperwork today for a new job at, where was that, Mr. Morgan?
Eagle Machining in Fayette.
Can you say that again?
Eagle Machining in Fayette.
Okay, and you can make a payment of $500 today, Mr. Morgan?
I can.
Your Honor, we would ask that this matter, Mr. Morgan be given a PR bond to make a $500 payment today, and then this matter be adjourned a couple of weeks, giving Mr. Morgan time to get this job, Your Honor, and see if we can get some income withholding started.
Are you here with him, ma'am?
Sorry?
Are you, you're his wife, okay. Are you able to facilitate that payment today?
I would have to call his father and ask him.
Okay, so,
Yeah.
Mr. Morgan's wife is present and she states she could call his father to ask him if he'll make that payment. So
Yes,
I can set his bond at 500 and if it's posted, he can be released.
Okay. My
Is that
dad,
to be, where is that bond to be paid, Your Honor? I assume that's a $500 cash bond. Can that be paid at the
Mr.
jail or?
Anderson, would that be paid at the jail or at the front of the court?
Typically that's paid at the jail.
So, all right. Mr. Morgan, and Mrs. Morgan. Mr. Morgan, you're supposed to pay $351 a month in child support. You have an arrearage almost to the felony level. If you get charged with a felony, they will put you in jail, and unless you can post over 10%, they will not release you.
Okay.
Do you understand that?
Yes,
So, you know, you have to work. Whatever your problem is that you're not working, you figure that out. If it's a seasonal job, you get a job in the off season, you know. You do what you gotta do, and your wife married you, so, you know, she's gotta accept that income from your household is going to that child support. So, what I'll do is I'll set this over to June 12.
Thank you, Your Honor.
At 8 a.m., sir. Mr. Morgan, I want you, when we come back on June 12, I'm gonna set your bond at 500 cash too. When we come back on June 12, I want that to be, you can do that via Zoom. Two things, if you're gonna pay, let's see, you gotta pay down your arrearage. You actually have to pay $400 a month in child support. If you're not working and you need to have your child support recalculated, or if you get a job that doesn't pay as well, then you need to come here and set up a hearing to have that reviewed. Do you understand?
yes,
If you have more children than what you're being given credit for, you need to have a hearing so that your child support can be recalculated. Do you understand that?
yes,
If you don't take care of those things and you don't do what you're supposed to do, it keeps charging, and then you end up at the felony level. Do you understand?
yes.
You have, let's see, your caseworker is it Amy Fetzer-Wallet?
It used to be Mike McCarron, so I'm not sure who my new one is.
Yeah, actually,
Mr.
it's
Anderson?
me, Your Honor.
All right, so Jeff Anderson is your caseworker. He's a good guy. You call
Okay.
him, if you come in front of the court to try to chat with him, he will point you in the right direction. But so you're gonna need to pay $100 a week. After you pay the 500 to get out of jail, you should pay 500 or $100 a week. If you get a job and they start taking your child support out, then until they start taking out of your check, you need to make the payment online. If they only take $351 out of your check, you need to pay the extra $50 a month. You got it?
Yes.
Okay. Do you have any questions, Mr. Morgan?
Nope.
All right, I will set your bond at $500. That can be posted at the jail and they'll release him. And I'll set this over to June 12th at 8 a.m. When you come back on June 12th, I want to hear you have a job and you've made payments. Got it?
Understood.
All right. Do you have any questions, Mrs. Morgan? No. All right. Thank you.
I have one question real quick.
Okay.
While my wife's still in there, so as soon as so all she has to do is show up to the jail with the $500 and I'll get released?
Yep.
Okay, I just want to make sure she understood that.
Oh, she understands.
Okay, thank you.
All right. Thank you.